All we say to America is to be true to what you said on paper. And we have come here to dramatize a shameful condition.
From the safety of secret committees, they talk about the danger of war.
In a recent action, commenced under the Federal Racketeering Statute and various other state and federal statutes, in the Federal District Court for the District of Columbia, Major Mike Webb has named as defendants Virginia Democratic Caucus House Majority Whip Alfonso Lopez, Sheriff Jose Quiroz, the County of Arlington, the Arlington Democrats, Ivy Crimmins LLC, doing business as Infinity Apartments, Capital Investment Advisors LLC, doing business as Infinity Apartments, Gretchen Rainmeyer. The Registrar for Voting Records, the Arlington County Electoral Board, the State Board of Elections, John O'Bannon, the Chairman of the State Board of Elections, Meta Platforms Incorporated and Twitter Incorporated. The intriguing thing about this action is that it not only has been brought against the Arlington Democrats who have held themselves out as champions of progressive causes, but also that it has alleged violation under the 14th and 15th Amendments, generally allegations that they have raised against the Republican Party, in their repeated claims that democracy is at stake. Amongst other protections provided, under the 14th Amendment, all persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property, without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Under the 15th Amendment, the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. Under 52 U.S.C. Section 10302, whenever an aggrieved person institutes a proceeding under any statute to enforce the voting guarantees of the 14th or 15th Amendment in any state or political subdivision, the court shall authorize the appointment of federal observers by the Director of the Office of Personnel Management. When courts, in the past, have defined an aggrieved person, this legal concept or term of art has usually been subject to challenge by a defendant on the basis of standing. And the federal courts have held that, to establish standing, the plaintiff must show 1. An injury in fact, 2. A causal connection between the injury and the conduct complained of, and 3. That the injury is not speculative and will likely be redressed by a favorable decision. So, first, in a challenge to standing, a matter of what is described by courts as personal jurisdiction for the court to hear, in this case, the plaintiff's claims, a defendant can, in rebuttal, present an argument that a plaintiff had not established an injury in fact, and, to establish an injury in fact, the plaintiff must show that he personally has suffered some actual or threatened injury as a result of the putatively illegal conduct of the defendant, and that the plaintiff cannot base his claims on the legal rights or interests of third parties or on generalized grievances or abstract questions of wide public significance. Simply stated, at least, the plaintiff must assert his or her own legal rights and interests. Second, in a challenge to standing, a matter of what is described by courts as personal jurisdiction for the court to hear, in this case, the plaintiff's claims, a defendant can, in rebuttal, present an argument that a causal connection between the injury, in this case, any claims brought by an aggrieved person instituting a proceeding under any statute to enforce the voting guarantees of the 14th or 15th Amendment, and the conduct complained, but how the D.C. federal court shall define an aggrieved person in a recent action filed under this voting rights provision remains to be determined, and Democrat Party House Majority Whip Alfonso Lopez and the Arlington Democrats have yet to file their rebuttal against recent allegations. Third, in a challenge to standing, a matter of what is described by courts as personal jurisdiction for the court to hear. In this case, the plaintiff's claims, a defendant can, in rebuttal, present an argument that the injury is not speculative and will likely be redressed by a favorable decision. At the commencement of a civil action, to survive a motion to dismiss for failure to state a claim, neither a formulaic recitation of the elements of a cause of action, nor naked assertions devoid of further factual enhancements will suffice. And a claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. The factual allegations must permit the court to infer more than the mere possibility of misconduct based upon its judicial experience and common sense. However, at least in the past, federal courts have held that speculative fear of future harm does not constitute an injury in fact sufficient to confer standing, but, after sweeping lockdowns and masking mandates had been upheld for the government based upon concerns about inestimable losses of life and harm, how the D.C. Federal Court, where this recent action had been filed, shall define an aggrieved person in a recent action filed under this voting rights provision remains to be determined. And Democrat Party House Majority Whip Alfonso Lopez and the Arlington Democrats have yet to file their rebuttal against recent allegations. At least in the past, federal courts have held, as to allegations, cursory and highly speculative arguments are an unacceptable substitute for the reasoned evaluation that is required, but how the D.C. Federal Court shall define an aggrieved person in a recent action filed under this voting rights provision remains to be determined, and Democrat Party House Majority Whip Alfonso Lopez and the Arlington Democrats have yet to file their rebuttal against recent allegations. Generally, for cases decided before the courts, for allegations, at least three different standards of proof are within the realm of possibility: proof beyond a reasonable doubt, proof by clear and convincing evidence, and proof by a preponderance of evidence. However, under 52 U.S.C. Section 10302, the court must act before the claim is even heard on the merits, and any challenge in rebuttal may only test the sufficiency of the pleadings, while courts have held that all allegations must be accepted as true, provided that they satisfy the threshold of facial plausibility. When a motion to compel the court, in mandamus, to appoint federal election observers has been filed, the court need not authorize the appointment of observers if any incidents of denial or abridgment of the right to vote on account of race or color, or in contravention of the voting guarantees set forth in Section 10303, F2, which extends protection to the right of any citizen of the United States to vote because he is a member of a language minority group, in only 3 instances, when the violations or infringements, 1, have been few in number and have been promptly and effectively corrected by state or local action, 2, the continuing effect of such incidents has been eliminated, and 3, there is no reasonable probability of their recurrence in the future. So, for Delegate Alfonso Lopez and the Arlington Democrats to defeat this recent court filing, they must not only establish that the violations had not only been few, but also had been corrected by state or local action. They must establish and provide credible assurance to the court that such incidents had been eliminated, and that there is no reasonable probability of their recurrence. However, legally to present these arguments, they must admit that the conduct had, in fact, occurred, an intriguing challenge particularly for progressive advocates who have self-righteously claimed to be the champions of voting rights, and in Arlington, where at least signs have promoted the idea that hate has no home here, and that Black Lives Matter. So, stay tuned for more developments in this novel and exciting political contest in Virginia's 3rd House District, as Major Webb takes the whip to Virginia Democratic Caucus House Majority Whip Alfonso Lopez, and in November remember, Webb, for voting rights. Lopez, against voting rights.
And we have come here to dramatize a shameful condition.
This message was approved by Major Mike Webb. Honest.